My brother shook the lawyer's hand while I sat across the table and said nothing. The document in front of me had my name on it, so did the line at the bottom waiting for my signature. My brother's lawyer smiled. My own lawyer pressed his knee against mine under the table. A warning. A plea. I picked up the pen anyway. My brother exhaled slowly, the way people do when they've been holding their breath for months. I signed. And that was the moment everyone in that room believed it was over. It wasn't. The letter came on a Thursday in late February, wedged between a flyer from Canadian Tire and a notice about recycling pickup. I remember because Thursdays were the days I drove my grandmother to her physiotherapy appointments in Barrie, and I'd come home tired, boots still damp from the parking lot slush. I set the letter on the kitchen counter and made tea before I opened it. I wasn't expecting anything important. The return address was a law firm in Toronto. My brother's name appeared in the second paragraph. I read it twice standing at the counter, mug warm in my hands, tea going cold anyway. My brother was claiming half ownership of the workshop. Not a house, not land exactly. A property in Muskoka, an old workshop, and the 2 acres it sat on, the kind of place that doesn't photograph well but means everything to people who grew up there. My father's father had built it in the 1970s, used it for woodworking, rented the back portion to a small furniture maker for years. When my grandfather passed, it went to my father. When my father's health declined 7 years ago, he asked me to take over the management. Not my brother. Me. My brother lived in Calgary then. He had his own life, his own business, his own reasons for being far away. I was the one who stayed. I put down the mug. I looked out the window at the backyard, at the snow collecting along the fence line. I felt something settle in my chest, not quite anger, not quite surprise, something quieter. The feeling of recognizing a door you didn't know was already closing. I called a lawyer the next morning. Her office was on the 2nd floor of a building downtown, above a dental clinic. She was direct, organized, the kind of person who reads everything before she speaks. She went through the documents carefully, turning pages without rushing. "This is based on unjust enrichment," she said finally. "He's arguing that because your father never formally updated the title transfer, the property reverted to the estate, and as a co-beneficiary he has a claim." "Is that valid?" I asked. She tilted her head. "It's arguable, especially if the title work was incomplete." "It wasn't incomplete," I said. "It was just never finished." She looked at me. "There's a difference legally," she said. "But it matters how well you can prove your role." That was the first time I understood that this wasn't going to be about what was true. It was going to be about what I could demonstrate. My brother and I hadn't been close in the way some siblings are the kind who call for no reason, who remember small things about each other's lives. We were close in the way that happens when you grow up in the same house and then slowly become separate people. We got along at Christmas. We texted when things mattered. When my father got sick, my brother flew in. He stayed for a week, helped with some of the early conversations about care, and then went back to Calgary. I didn't blame him. He had a family. He had responsibilities. What I didn't say, and what I should have said sooner, was that I had responsibilities too. I just carried mine without announcing them. For 7 years, I drove up to Muskoka every few months to check on the property. I arranged the annual inspection. I renewed the liability insurance. When the roof over the east section of the workshop needed repair, I got 3 quotes and chose the contractor. The repair cost just under $14,000. I paid it myself. Not because anyone asked me to, but because the alternative was letting water damage destroy something my grandfather had built with his own hands. I also dealt with the tenant situation. The furniture maker who had been renting the back portion retired in 2021. I listed the space, vetted 2 potential tenants, and eventually leased it to a small cabinetry business out of Huntsville. I drafted the lease with help from a local real estate agent. I deposited the monthly rent into the property account. I filed the income with my taxes every year, declared it properly, paid what was owed to the CRA. None of this was secret. My brother knew the property existed, he just never asked about any of this. The first hearing was procedural. I sat in a waiting area outside the courtroom in a chair with a small tear in the armrest fabric and watched strangers carry folders past me. My brother sat 20 feet away with his lawyer. He looked at his phone. I looked at the wall. We did not speak. That night, I lay awake thinking about the year my grandfather let me sand a cabinet in that workshop. I was 9 or 10. He gave me a piece of paper that was too fine for the job and let me figure out why it wasn't working. He didn't correct me right away. He waited until I asked. That was how he taught he let you feel the friction first. I thought about that a lot over the following weeks. My lawyer grew more insistent as the discovery process moved forward. She called me on a Tuesday evening from what sounded like her car, voice tight with focus. "You have documentation," she said. "The repair receipts, the lease, the tax filings. We can build a clear picture. His side has a legal argument but almost no factual backing. We push hard, we win this before it goes to trial." "I understand," I said. "Good. Then let me do that." I paused. "I haven't decided yet." She was quiet for a moment. "Decided what?" She thought I meant the strategy. I meant something else entirely. The discovery depositions were held in a boardroom on King Street. My brother wore a blazer I hadn't seen before. He looked composed, which surprised me, because when I looked at him, I didn't feel anger the way I expected to. I felt something more like grief. He was recounting a version of events that wasn't false exactly, just emptied of inconvenient detail. He described himself as an equally invested beneficiary. He described the property as neglected. "Neglected," my lawyer repeated quietly, when she showed me the transcript later. She highlighted the word. "We have $14,000 in roofing receipts that say otherwise." "I know," I said. She waited for me to say more. I didn't. What I didn't tell her yet was what I'd been doing in the evenings since the depositions. I'd gone back through every document attached to the property. Not to build a case I already had one, but because I needed to understand the full shape of what I was being asked to give up, or keep. What I found wasn't a surprise to me. But it would have been a surprise to my brother. When my grandfather set up the property in the 70s, he'd worked with a local solicitor who had very particular ideas about land stewardship. There were covenants attached to the title, not unusual for that era in Ontario, particularly for properties near protected waterways. What was unusual was the detail. The covenants required ongoing maintenance standards, not suggestions, legal obligations, annual documentation of structural upkeep. Compliance with the Conservation Authority's guidelines for the creek boundary at the back of the property, and a specific clause about tenant use. The back portion could only be leased to businesses engaged in skilled trades or craftsmanship. Not retail. Not storage. Not sublet. I had been complying with every one of these conditions for 7 years without realizing I was doing anything unusual. I had simply done what made sense: maintain the building, chosen an appropriate tenant, kept records. My brother had never read those covenants. Neither had his lawyer, apparently. The night before the final hearing, my lawyer sat across from me in her office with a glass of water she hadn't touched. She had the look of someone who had rehearsed what she was about to say. "I am asking you one more time," she said. "Let me present the full case. We have everything we need. The documentation is clean, the tax history is airtight, the maintenance record is stronger than anything he can counter. We will win." "I know," I said. "Then why?" I looked at the files spread across her desk. My 7 years of receipts, organized by date, lease agreements, insurance renewals, CRA correspondence, a folder for the roofing contractor alone. "Because winning the way you want to win means turning all of this into a weapon," I said. "And I don't want to use my grandfather's property as a weapon." She was quiet for a long time. Then she said carefully, "What do you want to use it as?" I didn't answer right away. I said, "I want to hand it back and let him find out what it actually is." She closed the folder in front of her slowly. "That's a significant risk," she said. "I know." She looked at me the way people do when they disagree with you but can't find a reason to argue that you haven't already considered. Then she said, "I'll prepare the documents." The courtroom, the morning of the final hearing, was smaller than I remembered from television. Wood paneling, fluorescent lighting, a faint smell of old paper and coffee. My brother's lawyer spoke with the confidence of someone who had prepared for a fight and was pleased with his preparation. My own lawyer spoke carefully, each word placed like she was worried about the weight of it. When the transfer documents were placed in front of me, I felt the full quiet of the room. I thought about the cabinet I had sanded when I was 9. I thought about the $14,000 roof. I thought about every February drive up Highway 11 inches, the dark, radio on, heater working too hard. Then I signed. Across the room, my brother's posture changed. His shoulders came down. He exchanged a look with his lawyer, a look of relief, maybe, or vindication. His lawyer began gathering papers with the efficiency of someone ready to move on to the next file. Then he slowed down. He had reached the section at the back of the transfer package, the covenant schedule. Pages I had made sure were included in the transfer documentation, as legally they had to be. His eyes moved across the lines. He turned a page. He turned it back. He leaned toward my brother and said something quietly. My brother frowned. The judge had already moved to adjourn when my brother's lawyer raised a hand. He asked for a brief recess to review the attached schedules. The judge said, "They were part of the disclosed documentation." "Yes," the lawyer said. "Of course. We'd like a moment." The judge looked at him for a beat, then granted 5 minutes. In the hallway, my brother's lawyer spoke in a low voice with his client. I didn't try to listen. I stood by a water fountain with my hands in my coat pockets and looked at the floor. My lawyer came to stand beside me. She didn't say anything for a moment. Then she said quietly, "He just found the covenants." I nodded. "He's going to have questions," she said. "I know." She exhaled slowly. "You prepared for this." "I prepared for the reality of it," I said. "There's a difference." She almost smiled. "That's the second time you've said that to me." When we returned to the courtroom, my brother's lawyer asked 2 careful questions about the Conservation Authority's compliance schedule. The judge directed him to the attached documentation. The lawyer thanked the court in the tone of a man who had just been handed a much larger file than he expected. The gavel came down. It was over. Outside the courthouse, the air was the particular cold of an Ontario March that hasn't decided yet whether it's still winter. My breath fogged in front of me. My lawyer pulled her coat tighter. "You know they're going to call you," she said. "I know. What are you going to say?" I looked up at the sky, the flat white sky, that means more snow is coming, the one that Ontarians learn to read before they learn to read anything else. "I'm going to answer their questions," I said. "All of them, honestly." She studied me. "And the property? That's theirs now. I meant it when I signed." She nodded slowly. Then she said something I didn't expect. She said, "I've been doing this for 14 years. I've seen people give up out of exhaustion, out of guilt, out of fear. I've never seen someone do it like this." "Like what?" I asked. "On purpose," she said, "with a plan that wasn't about winning." "It wasn't a plan," I said. "It was just I stopped carrying something, and I let him pick it up." My brother called that evening. I was making dinner, the radio on low, sleet tapping at the kitchen window. I saw his name on the screen, and for a moment, I just held the phone. Then I answered. There was a pause before he spoke. He said, "Our lawyer says there are conditions attached to the property." "There are," I said. He said they're extensive." "They are." Another pause. A longer one. "Did you know about them?" he asked. "Before today?" "Yes," I said. He was quiet for a moment, then, "Why didn't you say anything?" I said, "You didn't ask, and I wasn't hiding them. They were in the title documentation. They've always been there." I heard him breathe. I heard something shift in that breath, the particular sound of someone adjusting to a new weight. He said, "How much does the compliance documentation cost? Per year?" I told him. I gave him the number I had been paying, quietly, out of my own accounts, without complaint, and without keeping score. I heard him absorb it. He said quietly, That's a lot." "Yes," I said. "It adds up." He asked about the tenant lease next, then about the Conservation Authority's annual inspection, then about the insurance requirements. I answered everything. I didn't make it easier than it was, and I didn't make it harder. I just told him what owning that property actually involved. Toward the end of the call, he said, "I thought this was straightforward." "I know," I said gently. He didn't say anything for a moment. Then, "You managed all of this for 7 years." "Yes. Why didn't you ever ask us for help?" I thought about that for a moment. Then I said, "I didn't know how to ask without it turning into an argument about ownership, so I just kept going." That landed somewhere. I could hear it. Before we hung up, he said not quite an apology, but something adjacent. He said, "I don't think I understood what you were doing up there." "No," I said. "I don't think you did." The weeks after that were quieter than anything that had come before. No court dates, no legal correspondence. Just time, and the particular stillness that comes after a long conflict finally releases its hold on you. My brother began to learn what he had taken on. He called with questions, practical ones, the kind that have right and wrong answers. What form does the Conservation Authority require for the annual submission? Who was the insurance broker? Was the cabinetry tenant's lease renewable or month to month? I answered everything. I forwarded the relevant documents. I did not volunteer to take anything back. He struggled with some of it. I could hear it in his voice, the specific frustration of a competent person confronting a task that requires knowledge he doesn't yet have. He hired a property manager in Huntsville to help with on-the-ground coordination. That was a good decision. I told him so. About 2 months after the hearing, he called on a Sunday afternoon. The conversation started with a question about the CRA filing for the rental income. Then, it shifted. He said, "I owe you an apology." I waited. He said, I thought you were holding on to it because you wanted control. I didn't understand that you were holding on to it because no one else was." I said, "I know." He said, "That's not the same thing." "No," I said. "It's not." We talked for almost an hour that day, not about the property. About other things, our father's health, which had stabilized slowly over the years. About my grandmother's physiotherapy. About a memory he had from the workshop. About our grandfather letting him use the lathe once, and being terrified the whole time. I laughed. He laughed too. He said before we hung up, "You could have made this much worse for me." "I could have," I agreed. He said, "Why didn't you?" I thought about that question for a long time before I answered. Then I said, "Because I didn't want to spend the rest of my life being the person who destroyed you in court to prove I was right, even if I was right." He was quiet. Then, "Grandpa would have understood what you did." I swallowed. I said, "I think he would have." After we hung up, I sat at the kitchen table for a while in the last of the afternoon light. The sleet from those difficult months had given way to spring. The backyard looked different when the snow was gone smaller, in the way things often look when you can finally see their actual shape. My lawyer called the following week to close out the file. She asked how I was. "Better," I said, genuinely. She said, "Your brother reached out to me. He had some procedural questions about the title transfer. She paused. He was different than I expected." "He's learning," I said. She said, "He told me he hadn't realized how much work was involved." "That took a while," I said. She laughed softly. She said, "You know, the outcome here wasn't what I planned for." "I know." But she said it worked, in the way that things sometimes work when you're not trying to force them. I said, "That's the thing about responsibility. You can hand it to someone as a gift or you can hand it to them as a lesson." I wasn't sure which one this was going to be. "Which was it?" she asked. I said, "I think it turned out to be both. My brother and I aren't repaired. Not in the way that word usually means. We don't call every week. We don't pretend the lawsuit didn't happen. But something between us is more honest now, cleaner in the way that things can only become clean after you stop pretending about them." He drove up to see the property in April. He called me afterward. He said the workshop was in better shape than he expected. He said the tenant from Huntsville seemed solid. He said he stood in the main room for a while, looking at the workbenches our grandfather had built, and he thought about things. I asked what kind of things. He said, "The kind you can only think about when you're standing in a place that someone else has been taking care of for a long time." I said, "Yeah, that sounds right." For anyone listening who has been quietly carrying something, a property, a responsibility, a role in a family that no one else stepped up to fill, I want to say this clearly. The weight of it is real. It is invisible to people who aren't lifting it, and that invisibility does not mean it doesn't exist. Your effort is documented, even when no one is watching, even when the only record is your own. I didn't win in the way courts usually measure winning. I gave up a property my grandfather built, that I had kept alive for 7 years. That was real, and it cost something. But I also stopped carrying something that had quietly become the center of a relationship that wasn't working. And in the space that left behind, something else became possible, not reconciliation in the storybook sense, but the kind that's actually available to real people. The kind where you stop pretending, stop performing, stop waiting for someone to finally see what you've been doing. You let them find out on their own. And you trust that reality is honest, even when people aren't. If this story stayed with you, sit with that for a moment. Think about what you've been maintaining quietly, and ask yourself whether you're doing it out of love or out of habit or out of fear. Those are different reasons and they lead to different places. If you'd like to hear more stories about family, responsibility, and finding a way forward that doesn't require anyone to disappear, you're welcome here. Thank you for listening.